Okay, so this case right here is New Jersey versus TLO, and this is one of the coolest cases that I have ever read or ever seen so far. So if you want to follow along with this because it's super confusing, it's on page 469. But basically what happened, so this case was eventually decided by the Supreme Court of the United States in 1985. This is what happened. In 1980, there was a young girl, TLO. She was caught by a teacher smoking in the bathroom. Well, the teacher discovered two girls, and there was an odor of smoke in the bathroom, so he concluded that they had been smoking. Now, because smoking was a violation of a school rule, he took the two girls to the principal's office. One of the girls admitted to smoking right away, and another girl, TLO, she denied smoking in the bathroom, which was the rule, because smoking in the bathroom was against the rule. She denied smoking in the bathroom, and also on top of that, she claimed that she did not smoke at all. Now, you may think that's not important, but it ends up being super important here at the end. So, basically what happens is they get to the principal's office. They go to the principal. His name is Mr. Choplick, which just adds to the awesomeness of this case. But Mr. Choplick says, or he talks to Miss TLO, and he doesn't ask, he demands to see her purse. So he grabs her purse, he starts looking through it. Well, sure enough, he finds a package of cigarettes. In removing the package of cigarettes from her purse, he, as he's reaching into the purse, he also notices a package of cigarette rolling papers. Now, at this point in time, from his experience, Mr. Choplick concluded that because she had cigarette rolling papers, she probably also had marijuana. So Mr. Choplick, the principal, continued to dig in her purse. Well, he keeps digging, and he ends up finding marijuana, a small amount of marijuana, a pipe, a number of empty plastic bags, a substantial quantity of money in $1 bills, and an index card that appeared to be a list of students who owed the girl money, and two letters from somebody that also implicated TLO in marijuana dealing. Well, at this point in time, because Mr. Choplick kept digging into the purse, he has concluded that that Miss TLO, or TLO, whatever we're going to call her, is obviously like a drug kingpin or something along those lines. Well, as we get back, we end up taking this to court for all kinds of reasons. The girl's referred to juvenile and domestic relations court. It becomes an issue. So her lawyer, or herself, like whoever, TLO, whoever's acting on her behalf, contends that the search by Mr. Choplick violated her Fourth Amendment right, which is unlawful search and seizure. Okay. As we go on, there's this whole ginormous section that talks about the Fourth Amendment as well as the 14th Amendment. The 14th Amendment, as it says, there's a section in the book that I want to read about the 14th Amendment, but it says, the 14th Amendment, as now applied to the states, protects the citizens against the state itself and all of its creatures, boards of education not accepted. These have, of course, delicate and highly discretionary functions, but none that they may not perform within the limits of the Bill of Rights. Anyways, and it goes on to say that because they are educating young minds, it's more important that they pay attention to that kind of stuff. So, her lawyer contends that she's violating the Fourth Amendment, that her Fourth Amendment rights were violated, and then also they use the 14th Amendment to back that up, saying that even boards of education or school districts are held responsible or must concur to the Bill of Rights, and that being said, the Fourth Amendment. As we go on through here, we start the whole argument process. So her lawyer makes a very, very valid point, talks about it. New Jersey, the state of New Jersey comes back and says, well, because we're acting in local parentis, we shouldn't have to be, we shouldn't be held under those same statutes. The court comes back and says, well, basically, you can't have it both ways. You can't say that in this occasion you're acting in local parentis, and this occasion you're not. So it's either got to be one or the other. So they shoot that argument down. And as you go throughout the rest of this section, they continue to shoot their arguments down for a lot of different reasons. But At the very bottom of page 471, it says the state of New Jersey has argued that because of the pervasive supervision to which children in the schools are necessarily subject, a child has virtually no legitimate expectation of privacy in articles of personal property unnecessarily carried into a school. The argument has two factual premises: the fundamental incompatibility of expectations of privacy with the maintenance of a sound educational environment, and two, the minimal interest of the child in bringing any items of personal property into the school. So those are the two factual, or the two factual premises for the argument. My favorite part is the next section. It says both premises are severely flawed. And I love this next paragraph on 471. It says, although this court may take notice of the difficulty of maintaining discipline in the public schools today, the situation is not so dire that students in the schools may claim no legitimate expectations of privacy. We have recently recognized that the need to maintain order in a prison is such that prisoners retain no legitimate expectations of privacy in their cells. But it goes almost without saying that the prisoner and the school child stand in wholly different circumstances, separated by the harsh fact of criminal conviction and incarceration. So, schools and prisons are different, believe it or not. The last section that says here, we are not yet ready to hold that the schools and the prisons need to be equated for purposes of the Fourth Amendment. So they come back, they talk about this some more. It ends up talking about the students. Students do have, they have needs at school. They need to be able to carry certain things at school, different hygiene items, keys, money, different stuff like that they should not be subject to search. So it goes on, and they start giving their legal rationale for it. It says, how can we strike a balance? They talk about warrants. They say that warrants in a school system are not necessary, and it would create a huge issue in requiring teachers to get a warrant before searching a student or searching their property. So basically they come up with this test, which they're going to call the reasonable test, or the reasonability test. The reasonability test says that the legality of a search of a student should depend simply on the reasonableness under all the circumstances of the search. Determining the reasonableness of any search involves a twofold inquiry. First, they must consider whether the action was justified at its inception. And second, they must determine whether the search actually conducted was reasonably related in scope to the circumstances which justified the interference in the first place. Basically, it says that it must not be excessively intrusive in light of the age and sex of the student and the nature of the infraction. So that's what they come up with. That's the test. So now applying it to this case, the state of New Jersey versus TLO, they say on page 473, right-hand column, it says, Mr. Choplick's suspicion that there were cigarettes in the purse of TLO was not, it was not just a hunch. It was a sort of common sense conclusion about human behavior upon which practical people, including government officials, which is also humorous, I think, are entitled to rely. So basically, that Mr. Choplick, because of the situation, could guess that there was probably cigarettes in that search, which made it a reasonable, common sense conclusion that he could come to. Now, she may not have had a package of cigarettes in there. She could have borrowed cigarettes from someone who'd been smoking them. But nevertheless, the requirement of reasonable suspicion is not a requirement of absolute certainty. So he didn't have to know there was cigarettes in her purse. He just had to be reasonably suspicious that there were cigarettes in that purse. As he searched for the cigarettes in the purse, he found them, which confirmed his common sense conclusion. So he found those, and in finding those, it led him to further and deeper means, meaning he found the cigarette papers, which, what should I say here, contributed to the reasonableness that he should continue to search. And finding that, he ended up finding the package of marijuana, the little baggies, the money, basically finds out that she's dealing drugs in the school. So at the end of the day, based off of those facts, the Supreme Court decided that the school district was in the right, that they did not violate her Fourth Amendment rights based off of this reasonableness test, because Mr. Choplick, sorry, because Mr. Choplick could act under a reasonable suspicion that there were cigarettes in her person, that she had therefore been breaking a school rule regarding that. I'm sorry that one took so long. I don't know how else to do it, but I thought that case was awesome.